Good morning, everyone. This is the Committee of Bar Examiners meeting for December 1st, 2023. I'd like to go ahead and open the meeting. So Devin, can you go ahead and do a roll call vote?
Yes, Dr. Bolton,
Here.
Robert Brody, Dr. Cow,
Here.
Alex Chan,
Present.
Jim Epting, Kareem Gangora,
Present.
Paul Kramer,
Here.
Larry Kaplan, Alex Lawrence,
Here.
Esther Lynn, Justice Macy Walla,
Here.
Bethany Peak, Ashley Silva Guzman,
Here.
Judge Reyna,
Here.
Vince Reyes,
Here.
Alan Yokelson.
Here.
We have a quorum.
Thank you so much, Devin. I'd like to start out by discussing public comments. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. The committee coordinator or chair will attempt to call members of the public in the order that they appear. To facilitate hearing as many members of the public as possible, I encourage you to not repeat points that were made by previous speakers, and to allow the committee the time needed to deliberate on the important topics that we will be discussing today. We'll be limiting public comments to 2 minutes per person. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make public comments, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify raise hands and will enable the microphones of the speakers. Devin, are there any public members that wish to make comments?
Yes. Our first public comment will be from Todd Hill.
Ladies and gentlemen of the Committee of Bar Examiners, thank you for giving me the opportunity to address you today. My name is Todd Hill, and I'm here as a student who has faced a challenging journey through legal education. I'd like to share a story from my childhood, a lesson my mother taught me, and the reasons why I believe the conferral of my degree should be a real priority for this esteemed body. When I was a child, my mother took me to the Holocaust Museum, a place that serves as a solemn reminder of the consequences of injustice and the importance of standing up for what is right. After our visit, we sat in a park eating ice cream, and she told me something I've never forgotten. Everyone can be wrong, everyone can know they're wrong, and everyone can persist in the wrong for a protracted period of time. This lesson has stayed with me throughout my life, guiding me to question the status quo and advocate for justice when I see wrongdoing. I matriculated into the People's College of Law with a deep sense of purpose, driven by a desire to make a positive impact in the legal field. During my time there, I discovered an unlawful scheme within the institution, one that jeopardized the futures of my fellow students and me. I believed it was my duty to report this misconduct to the appropriate authorities, and I turned to the State Bar, trusting in its commitment to public protection and its mandate as the sole regulator responsible for post-secondary legal education services. However, to my dismay, the State Bar failed to timely act on my report. I learned that there were policies in place that communicated to predatory schools that the State Bar would not intervene in conflicts between students and their institutions. This policy, in my view, contradicts the core principles of the State Bar's public protection mandate and is inappropriate for an entity tasked with overseeing legal education. In response to the State Bar's inaction and for the ongoing non-compliance of the institution, I've been left no choice but to file a cause of action in federal district court, identified as number 2:23 CV-01298-JLS-BFM. The facts of the case are simple and clear. The State Bar has chosen to obfuscate and delay, seemingly in support of a school that has admitted to its noncompliance since 2017 and remains noncompliant to this day.
Thank you for your public comment.
Thank you for your time and consideration.
Our next public comment is from Ray Hayden.
I always make a public comment for the public commenters. If you can't really see that little clock above Vivian's picture there up in the top right-hand corner, it's kind of a double clock, got a green square around it and the time sticking away. All right, so my first thing is a compliment to Cal Bar for the discussion that's going to happen today on using multiple choice questions only for the first year law students examination. I'm going to jump over here to item 3B, October 2023. I'm going to read it real quick. It's real short. And it starts out, in short, the report reached the following conclusions regarding the first year law students examination. 1, performance on the first year law students exam is a strong indicator of CBX performance. The scores from the essay section were only weakly related to CBX scores, and the reliability and predictability and predictive validity of the first year law students exam would be most improved by eliminating the essay section completely. Now, this goes along with comments I've been making for a couple of years at California Bar through public comments and reports and stuff like that, where I'm a big fan, much like Tracy Montez from the Blue Ribbon Commission is, on multiple choice questions, but they must be done right. I'm getting ready to take another recertification for my commercial drone pilot certification, which we have to do every 2 years. We must score 100% perfection on that exam. If we get a 99% right, we fail. We get to try it again in a few weeks. So, but it's something that you can do it again, but you have to score pure perfection. Now, this doesn't come out of the blue. The FAA gets it, and of course, they're governmental, so is the military. Years ago, I was put in a program, course for authors for the Air Force, and I was taught how to make these multiple choice questions, and they're not that difficult to do. Find your subject matter experts, you get your questions done, you validate them before the exam goes. I believe the big bar exam can be done that way as well. All right, so I'm running out of time, so I'm gonna cut it short there. Have a great meeting, and we'll talk to you next time.
Thank you. Our next public comment is from Benjamin Cohn.
Hello, thank you. A little bit confused that the public comment is being set at 2 minutes instead of 3 minutes for the second meeting in a row. I thought the Board of Trustees had set the default at 3 minutes unless there was a number of public commenters that could not otherwise be heard in 2 hours. But anyway, the matter of the testing accommodation security for remote implementation doesn't seem to be on the agenda and for this meeting, and I was under the impression that the Board of Trustees would be making a decision at it at its January meeting. I'm not sure if you intend to do a special meeting, but I think you should, if you need to, in order to have a recommendation made to the board before it acts and makes a decision on that for July 2024. I believe that decision should be to do the multi-camera one that was in the staff presentation for the last November board meeting. But if you don't think the technology can be worked out at scale in time for July 2024, you should do a pilot for those who want remote testing as a testing accommodation for July 2024, and then scale it up as soon as you think the technology can be reliable. We don't need another July 2021 meltdown either, but that's, I think, the best way to do it. And I do appreciate the new format that was more interactive and staff giving questions follow-up to clarify their concerns with the substance of comments at that last forum on November 3. So thank you for that. All right, that's it. Thank you. Have a nice meeting.
Thank you. We do not have any additional public comments.
We would like to thank everyone for the public comments. The committee bar examiners takes all comments very seriously, and we appreciate your time and your input. Moving on to our next agenda item, approval of the October 13th, 2023 Committee of Bar Examiners public meeting minutes. Are there any questions or comments concerning this agenda item at all?
I'll make the motion to approve, Chair.
Thank you so much, Kareem. May we get a second?
Can I just make a comment? Oh, I'm sorry.
Go ahead, Justice.
Oh, my name is spelled wrong on the meeting the minutes, and I think it may be spelled wrong on other minutes as well. So I just would ask if we could amend the minutes to spell my name properly. And then with that, I would love to second the approval of the minutes.
Justice, first of all, we want to apologize if we misspelled your name. So
Okay. It's a hard
that-
name to spell.
okay. Thank you so much, Justice. And then also thank you for seconding the motion. Is there any other discussion or comments or revisions on the minutes? If there's none, then we will go ahead. Devin can do a roll call vote for approval of the minutes.
Dr. Bolton,
Yes.
Robert Brody, Alex Chan,
Yes.
Jim Efting, Kareem Gangora,
Yes.
Paul Kramer, Larry Kaplan.
Yes. Sorry, yes.
Thank you. Alex Lawrence,
Yes.
Esther Lynn, Justice Macy Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 12 yeses and 0 nos, the motion passes.
Thank you very much, Devin. Moving on to our next item. We're going to just make a slight modification on what's going to be discussed next. It's listed as the chair's report, but what I'm going to ask is Audrey, if you could talk about the planning session, because this is really the importance of this meeting today, and we want to make sure we give it the proper time that it deserves. Audrey, can I turn it over to you?
You sure can. Yes, thank you. So we're going to start with the planning session right now at the top of the agenda. Before I start to share the slides, I did want to also welcome, I think I saw both of our board liaisons are on the meeting today, Mary Huser and Brandon Stalling. So we have new Board of Trustees liaisons, so just welcome to them. So I'm going to be taking my PowerPoint up and down a lot today because we're doing this planning session in a Zoom format, but I want as much engagement and discussion since it's a very important part of our CBE year to plan. And so if you see my slides come up and down a lot, hopefully it doesn't give you PowerPoint whiplash, but we're just going to try to see each other's faces while we're also discussing these slides. And I apologize if I sound a little off. I have a cold, but hopefully you can hear me okay. All right, so we're going to go through our planning slides. And like I said, I'm going to take things up and down so we can also see our squares and discuss. I'm going to talk about some pending work for the entire committee of bar examiners. And then we're going to go through testing accommodations and eligibility planning, examinations planning, moral character, and finishing out with ed standards, including CS bars and law school council. So some really important pending committee work that we are waiting on the Supreme Court about. I'm sure you all know, but the Blue Ribbon Commission recommendations on the future of the California bar exam are with the court. Included in those recommendations was a recommendation about reciprocity. So that could be a possible rule revision in 2024. And then from the November 16th meeting of the Board of Trustees, the Supreme Court will now be considering a pilot portfolio bar exam using the 2020 originally provisionally licensed lawyers to pilot that program. So that is all kind of out there, and we will hopefully hear back from the court on these items in the very early part of 2024. So I just want to mention that's kind of an overarching pending work for our committee. Testing accommodations and eligibility. Ashley and Christina.
So Ashley has been gracious enough to volunteer to present the testing accommodations, the accomplishments that we've covered over the past year, our current work plan, and what we have in mind for the upcoming year. And I will throw it to Ashley. Thank you, Ashley.
Hi all. So I'm really happy to be serving as the vice chair this year, along with Robbie as the chair. So some of our accomplishments you can see on the screen here is we've done quite a few rule revisions. We've reviewed and revised the admissions rules relevant to the testing accommodations, and those are pending Supreme Court approval. Obviously, that took quite a bit of time and a lot of edits, and hopefully we're in their best form at this point. I know we all put a lot of work into it, especially prior to my arrival. So there was a lot of back and forth, and we really appreciate all of the public comments that came forward with that process as well. We've also reviewed and revised the admissions rules relevant to eligibility and special admissions. That's pending Board of Trustees approval to circulate for public comment, which we really hope that we'll get some great feedback on that as well, because those are really important rules that affect the admissions to the bar as well. We're considering petitions seeking waivers of the committee's eligibility related policies, procedures, and rules, and then considering testing accommodation requests for review of appeals from applicants. So those are our accomplishments and ongoing initiatives for this year and last. And then our current work plan. So testing accommodations, we're implementing the revised rules and related changes. A good portion of that is also trying to see what we can do to investigate speeding up that process, looking into any additional rules and revisions that are needed as we're going along that process, and then obviously getting back from the Supreme Court the testing accommodation rules that we've already submitted. As far as the eligibility, we're continuing that process as far as the special admissions, eligibility, law of study, and the practical training of law students, all of which is especially important as we're getting into this kind of blue ribbon commission idea and this alternative pathway, because those are serving as, I think, a really strong basis for what that will look like. And so that's our current work plan. And then
should we ask questions along the way, or
yeah, so do we want to do questions for each page, or do we want to do, what do you think is best?
Go ahead, Dr. Kell.
Oh, go ahead, Audrey, please.
Oh, I think the next slide is when I might be taking it down, so we can hold it, or we can ask if it's related to this, if it's related to the current work plan.
Oh, yeah.
This one? Oh, well, this is the implementation item.
Mm-hmm.
Remind me, are we planning, if the rules are approved by the court, and having the subcommittee consider all of the testing accommodations so they will no longer come before the full committee? Is that still the plan?
Yeah. I think that's the end goal. Christina, is that right?
That is correct, yes.
Okay, so, and those may or may not be combined with regular meetings of the CBE if the dates work out.
Yeah, and hopefully we can have more so that we can approve more as, you know, they're coming in, so that they're not waiting for as long of a period of time.
Okay, I have no problem with that. I was just trying to remember what we were up to. Thanks.
Thank you. All right. And then I think we were in, additions to the current work plan. So I think that's one of all the other programs and projects we're working on is continuing to explore ways to make the remote testing accommodations secure, since that's also going to be a big factor in how we're administering the test and administering testing accommodations for remote. We have some, I think, good practice from the COVID years, and so working on what that looks like as well to make that as secure as possible. And I think you mentioned this might be the last slide.
Yeah, it was you wanting to brainstorm any other additions here?
Yes, that would be great.
All right.
Okay, any questions, comments, concerns, ideas for our work plan? Okay, I'm not seeing.
Audrey, I believe there was one more slide about the training topics. We, with Ashley and Robbie, had come up with a few suggested training topics for the upcoming next year, but I was also wondering if there are other training topics that we might be interested in hearing about, learning about for the whole committees. benefit.
Christina, if I may ask, what's your timeline for these training topics for the committee to know?
So the substantive issues for the testing accommodations request, that has been asked by some of the newer members on the CBE. So I would like to get that early in 2024. Perhaps the March meeting would be the right place for that. The presentation for the admissions staff on the various special admissions programs, we just thought that maybe the committee members, maybe those that have been on the committee for some time, or maybe the new members might be interested in hearing all the wonderful programs that the State Bar offers for special admissions. That's not really a time-sensitive presentation, so that really can go whenever we think the agenda would allow for it.
Well, we did recently overhaul those rules, so so they may not be coming back before us for some time. I don't know how that affects the immediate need for that particular training.
And wanted to get any other ideas for eligibility, special admissions, testing accommodations, where committee members may be interested in learning more, if you have any. If you can't think of any right this second, you're always welcome to email Ashley, Robbie, or myself, and we would be happy to put those trainings and those educational pieces together.
Christina, I have a question. So for testing accommodation applicants, are we going to still be doing our same process that we have been doing until we hear back from the court? Or is there going to be any change so that we're aware of that?
Yeah, so we have been working with our new process, meaning that our new streamlined process. So anyone that has been applying for testing accommodations have been granted, the same testing accommodations that they received on other high stakes exams. That process will continue. We have to follow, obviously, the rules that are in place now. And so we will be constrained by some of those rules, but for the most part, we are in our new process in terms of just streamlining the process.
Dr. Howe, are you also asking about the process where the admissions subcommittee is handling all of the reviews, or was that your question?
I just had a general question, Ashley, and yeah, so wasn't actually any specifics. I think I just wanted to make sure that the committee members knew where we were and how we're doing things, since we're making a transition, but where are we actually implementing it?
Yeah, and Ashley, that was a good thought too, just to clarify. So the rules currently say that the entire committee is going to be listening to the testing accommodation appeals. So that part of the process will remain a full committee function until and when, or if and when, the testing accommodation rules go into effect. Then we will bring them out into just the subcommittee. But until those take effect, it will be the full committee. Thank you for bringing that up, Ashley.
Okay, I didn't see any other questions or comments. So unless someone wants to speak now, forever hold your peace.
Maybe not forever. If something comes up, we can always come
No,
back.
never. Email us after.
That sounds like a new rule.
Right? Email myself, Robbie, and Christina if you have anything that comes up after the meeting. Thank you.
I'm sorry, I have a question. Can you clarify? So the idea of moving the testing accommodation appeals to the subcommittee from the full committee, that's in progress, but that's not happening immediately, correct?
Correct.
Also, just a quick question, the time limit of the 35 days or whatever it is to explore that, that's not been decided. That's going to be talked about, and we can talk about that timeline later.
Yeah, I believe that's actually already up to, is that right? Up to the Supreme Court, or is that still up for discussion, Christina?
Well, I'm not exactly sure which topic. There's a couple of timelines. There is a motion, though, that the committee, after 2 bar exam cycles, is going to look to see if they can streamline the not streamline, make decisions, become, have decisions faster or streamline the decision process. That will be after we have fully, updated the AIM system, which is the applicant portal that people request accommodations, the forms. After everything is in process for 2 bar exam cycles, we'll bring that back to the entire committee for review. Was that what you were referring to?
Yeah, I was just, I saw when I was reviewing it, and I don't know if it was this part or not, but it was that usually it's a 90-day process, but then they were talking about making it 35 days. And if I was just wondering if it's a subcommittee that's doing it, that means that I think the subcommittee of this committee, right, would be reviewing those within, having to review those within 35 days. And I was just curious about that process, but it sounds like we can talk about that later.
Yes, the timelines right now that we're just holding on to, we didn't change the timelines in the existing rules. It's 60 days, 30 days for staff to come back and say we need more information from an applicant, and then 60 days for either a decision to be made or letting the applicant know that their file is still pending.
Okay, thanks.
Okay, I'm gonna start sharing again. So we're gonna move on to examinations. Kareem, Amy, and Tammy.
Good morning, everyone. The following slides will encompass everything that is considered examinations, which will be the administration of the exam, grading, as well as exam development. And we're going to hand this over to Kareem Gongora, who is the chair of examinations for this next year. Kareem?
Awesome. Thank you, Tammy. We're going to run through this as quickly as we can and want to celebrate some accomplishments. So thanks to the State Bar and the committee's leadership and also our staff to help us usher some of these things along. The CB response is needed to recommendations and narratives of the Blue Ribbon Commission final report, input on the Board of Trustees review of examination application fees. Remember how much of a spirited debate that was. So kudos to you all for being engaged and involved in that. Reviewed and revised admission rules relevant to grading. So that's in the process of pending Supreme Court approval. Review and revise admission rules relevant to the exam administration. That's pending CB approval to circulate for public comment. We completed the pilot CA bar exam experiment, and that has come into a much more bigger topic. So thank you for your support on that. Approved eliminating the essay portion of the first year law examination and or revisiting exam weights. And then the Board of Trustee review examination, that's going to be, that's approved by the Board of Trustees for implementation in the upcoming new year. So kudos to you all for being involved in that and helping us support that along the way. So next slide, please. Ongoing initiatives that are being continued. So providing input for the Board of Trustees review of examination and application fees. And then on the Blue Ribbon Commission report and recommendations, reviewed and revised admission rules relevant to Chapter 6 grading rules and the processing of fees, considering appeals that are seeking waivers of the committee's exam-related policies, procedures, and rules. And then edited and approved final versions of the essay questions and select performance test questions for administration on the CBE. Reviewed reports on administrations of the California first year law exam and bar examination. So a lot of work. I mean, all that is not done in isolation. It takes a team and it takes a lot of work. So these things will be ongoing and just things that will be continuing on. The next slide should be things that we are in the current work plan. And so one of the things we're looking to tackle is continuing the rule change process for the exam administration, considering conducting a standard setting study to determine whether the passing score for the first year law exam should be raised or lowered. And that's something that I thought would be something that's kind of been along the line of the work that we've been doing for the past couple years. And since I've been on, there's been a lot of discussion about passing scores. So we'll see what that pulls out for us and wait for that report. Consider draft reports to the Supreme Court of California on the July 2023 bar exam and then the October 2023 first year law exam, student exam. develop recommendations regarding certain components of exam delivery. This is all the buzz, right? Remote versus in-person, open book versus closed book, time limit on questions, which is informed by the Access Lex study. So we'll see what that delivers us and kind of what discussions we have. I know we all have been involved in this for, I mean, I've been on since 2018, and this has been a discussion since then. So definitely looking to see where we are at this point in time and kind of some of the initiatives that have come before us and that have put us in this place. Examine specific testing accommodations to ensure that they meet applicant needs, ensure we meet ADA requirements and that are cost effective, such as investigating what constitutes a semi-private room. So this is something that's come up a lot in our exams, and I think it's something that we could take on and just have a general understanding of how do we define that and what does that mean, and those questions come up a lot in our deliberations. So I think it'd be a good opportunity for us to just educate ourselves and kind of move forward in that direction. So additions, these were things that when we discussed with the committee leadership, the subcommittee leadership, we were wondering what kind of items would kind of integrate what kind of the goals that we're setting from previous and current work plans, but then also definitely trying to understand that maybe there's some additional things we should consider to help meet the moment. So develop detailed recommendations related to reciprocity to assist the Supreme Court in responding to the likely recommendation of the Blue Ribbon Commission, review of the current NPRE cut score, evaluate whether to phase out handwriting options for non-TA, non-testing accommodation applicants on bar exam. So I think that wraps it up. If there's any question, oh wait, there's more. Sorry about that. Yeah, we did talk. Damn, we're gonna be busy. Awesome. I love this, Tammy. Look at this. We're gonna be very active this year. And so training topics. So this is something that I know I've been on 5 years. Some of you have been on quite a few years longer and have been involved in the bar. So sometimes there's things that I felt were I didn't know much of, or maybe I would love a refresher just so I can get a reminder. And so we're looking to have some training topics for 2023-24. So a presentation from the PT drafting team member on the basics of performance task development, presentation from the exam development and the EDGE team, and the basics of essay question development, and then the basics on scaling of the California Bar Examination. And all these things I think are actually good, like public information items as well, just because it's going to show a little bit more transparency in our procedures and kind of the work that goes into building up this exam that we administrate. And so we thought it'd be a good idea to kind of start with these three and open up for suggestions.
Also suggestions for additions to the work plan, right, Kareem?
Oh yeah, that too. I mean, sure, let's do it. let's add more items, Audrey. Oh, I see the great Mr. Chan has his hand up. Yes, sir.
I appreciate the awesome presentation. It's very helpful. One of the things I would like to talk about, perhaps it may be more appropriate for the closed session, is how we select the chapters of the exam questions and how we determine the competency of those chapters. I think for, being a member for a while now, I still don't really understand the process in terms of selecting or receiving the pool of chapters who are responsible for coming up or deriving and preparing those exam questions. I do think, this is an important question, especially when the selection would have an impact on DEI, among other things. And so, again, I think, this may be a better question for the closed session, but certainly it's one of the things that may be encompassed and captured by the second point in your last slide, which is the development of the exam, answering the basics as far as how we develop those questions. But I certainly want to make sure that we encapsulate the issue about, or just at least for those who are new to the committee, making sure we understand how we sort of, do the stuff in the back end, because I think that is a very important discussion, and also information for all the members to understand going forward. So,
thank you, Mr. Chen. If you don't understand it, then I don't understand it. So I would love to definitely place that item on our work plan, so it's something that we could discuss and kind of have a more clearer understanding of. So thank you for that that recommendation, Audrey. So we just add that on there.
I did. I can show you where I put it for now. I just added it.
And one of the things we didn't discuss, and that's kind of my failure, is prioritization of these items. So is there a way that we could do 1, 2, 3, 4, or is it just better that we take it when kind of things are, maybe that's a Tammy question. Do we do it like when there's momentum, when there's a more calculated moment that we could bring these issues forward?
I think that there's a couple of factors that go into that. And I think one is looking at when we can do it, when does it make sense to do it, but also looking at the workload with all other areas of CBE, that if we're bringing everything in one specific month, is that going to work for CBE to have their meeting and be efficient in the meeting and get what they need done? So I think we could order them in the order that we want to do them, but also allow flexibility that if we have to shift it, that we can do that.
Okay. I don't
There's
think,
also a slide in our PowerPoint here. I think it comes towards the end in our planning session where we've put kind of try to pace our presentations, because I think that's been a challenge for us throughout the year. Is
yeah.
we've been putting too many all perhaps in one session. So I think internally, if we try to spread them out among the units, I think that will be will keep the pace in terms of the training sessions and and ensure that we cover business and have trainings at each of the sessions.
Okay.
Might I suggest that idea be expanded to talk about the whole process of drafting, to educate us? Because I don't think we've heard about that for quite a while.
We can do that.
And then I had a question. We have the exams committee looking into the efficacy of accommodations, but why isn't that assigned to the accommodations committee, who perhaps has more on the ground experience with, because they're reviewing the appeals every time we meet?
Oh, I think I know which item you're talking about. Let me share it. I mean, looking at how we in the exam meet those. So I think it's because we're talking about how that in our facilities, or if we move to examining it from the our examinations side, where we're seeing how we meet the accommodations. Like if we're a semi-private room is 20 or fewer, or is a semi-private room 10 or fewer. Like these are not in terms of what the accommodations process is, but how we might deal with it on like the facility.
No, I'm not talking about the process, but the people who, many of us, me by choice, if the new scheme is adopted, won't be, reviewing specific accommodation requests. But I think the experience of doing that informs this particular task as well. Maybe the answer is that because all of those people who are on the exam subcommittee will be part of the greater CBE as a whole, that their experience will be adequately factored into the analysis. So I'll withdraw the question. It just seemed odd that something very specific to testing accommodations was being put in somebody else's to-do list. And then one more thought. So the discussion we just alluded to about making sure that we don't overload our meetings raises the question, for me at least, about whether or not we should have some meetings that extend beyond a day. I know you wouldn't want the in-person meetings to be those because of the expense, but the actual costs of having a remote meeting like this to any of us, except for time, are negligible. So maybe we should have a couple 2-day meetings to make time for us to adequately discuss all that we need to discuss. Alex Chan is nodding his head. Yes, it appears.
Yeah, is that,
Yeah.
thank you for that comment. I see Dr. Cow does have his hand raised too, so I'm gonna have to recognize him. He is our chair, but we'll keep your item pinned too, Mr. Kramer. Yes, Dr. Cow.
Thank you so much, Kareem. Thanks for a great presentation. I had a general question, not actually specifically directed for you to answer, Kareem, but I guess a general question maybe for Audrey and the staff. One of the things I was trying to figure out is that in Kareem's presentation, he had mentioned that we're going to be looking at potentially raising or lowering the score, the pass score for the first year lawsuits exam. But then I know subsequently Paul's going to be speaking on this, and maybe I'm jumping ahead, but we were going to be talking about mandatory accreditation or possibility of mandatory accreditation for registered unaccredited schools. So my question is, maybe Audrey, like, when there's topics that overlap, and Paul alluded to this with testing accommodations, will those distinct subcommittees crosstalk with each other, or how do we do that? Because I think one may affect the other, or maybe I'm just thinking thinking a little too much into it. I just wanted to get our thoughts on that at all.
Or we discuss them as a full committee.
Yeah, everything is really discussed at the full committee now. The subcommittee labels are buckets that we put various tasks in, but the only real task that is dealt with by a subcommittee exclusively is testing accommodations. Right now, between meetings of the full CBE and in the future, if the rules are approved, for all testing accommodations. But otherwise, we always meet as a group, and a subcommittee doesn't do. It's, as we'll see when we go over our expectations in a few minutes, it's really there to focus, to allow people to focus where they feel that they can't give their full and complete attention to all the items on the table. We have a group of people who are expected, for instance, to be up to speed on the moral character items. And we expect them to take a deep dive, and those of us who have the time also can do so as well. But we're focusing people, but ultimately we all get a say in it because we don't discuss them separate from the full group except for testing accommodations.
And I agree with you, Paul, that I guess my question, maybe I just didn't ask the question correctly, was that is there ability for the chairs and sub-chairs of each subcommittee to discuss before we bring it to the full committee? So that there can be any other ability to kind of, think about what are the different suggestions that we could bring to the full committee?
Well, chairs and vice chairs can brainstorm with staff. We have to be mindful of not getting a quorum together. And so, I mean, that's another expectation we have of them, is that they will kind of vet staff proposals ahead of our meetings, not necessarily to, give them a thumbs up or a thumbs down, but to make sure that staff has included all the information we need and has answered likely questions that might come from any one of us. And I guess if we just have 4 people, 2 chairs, 2 vice chairs between 2 committees getting together on their own, that would not violate Bagley-Keene, to sort of vet things. They could do that as well. I can't remember it having been done recently. We basically had to kill off separate subcommittee meetings because it meant that the full group, we were talking about items twice during a meeting, once at the subcommittee and then back up at the full committee again. And that was thought to be wasteful of our time. And it caused people who were not on the subcommittee when the subcommittee was meeting to have to wait out in the hall, in some cases. And that, that really didn't appeal to people.
Yeah. So how do we want to approach that, Audrey?
Oh, I think that suggestion in terms of overlapping items, as long as those meetings wouldn't violate Bagley-Keene for the chairs, vice chairs to get together before the, I think that's not a bad suggestion.
Yeah, I don't think so either. Is that something that we would put on our work plan, or is that something just overall that's like committee administration?
Yeah, because I think the work plan, we're sticking to some of the higher level policy issues, but I think that suggestion would be something that the staff would be able to make. Go ahead, Paul.
That might fit well in the points of consensus document, which is I intended when we started it last year to be kind of a reminder of us all about what we think are our best practices. So, so maybe we'll carry them forward and not reinvent the wheel from administration to administration. So yeah, we're going to go over that in a few minutes, Cream.
Okay.
And
then, yeah.
we can just talk about where it might go there.
Okay, cool. And then I didn't want to overlook that I thought Dr. Cal had something to add to that, but the 2-day meetings or seeing what could be done to kind of create more of an engagement on the other topics that we don't get time to do. I know it's a staff impact too. So Audrey, I don't know if you had any feedback on that.
The only thing I would ever worry about with the 2-day meeting is quorum. So we would have to try to think about people's schedules, but we can also put a pin in that until the kind of administrative matters that are a little more in that consensus document. We can talk about that then too, or Dr. Cow and Alex can look at the 24 schedule, and then we can come back in January to see where we can make a 2-day meeting where it might make sense based on what we have, because we do have those training topics sort of calendared out in a suggested way. So we could look at which of those meetings might be.
Yeah, because I sit on the planning commission, and there's days where we just do workshop days. And they're like 2-hour meetings where we're just talking about, we're literally laser focused on one topic. And we're getting into the weeds of things. But it is held in a public forum, so that's used as a public information tool as well. So yeah, just any way that we could do that. I mean, I'm sure it would be hard to get quorum for another 8-hour day, but something that's like 2-3 hours might be beneficial, because a lot of these topics are very deep. And even if we bring on one of our experts to give a presentation, those things are fully in depth. And from my experience on the committee, we've got a lot of good discussion on a lot of these reports that we receive, and even just some of these moments of contention where we're just like, all right, well, what's going on? Tell us the truth, and just trying to understand what the impact is. So that would be my lens in looking at it. And so I think Paul for bringing that up, just because it's been kind of approached for quite some time, but maybe Dr. Cow and Mr. Chen could kind of lead us through that.
You're talking about 2-day meetings on a regular basis, or just once in a while as needed?
I think the goal is to figure out where we can do it. So not all the time, but in the moments that we can, see how we could do it. Because we also have the question selection days, the edge grading days, so those kind of things. The what is it called when you calibrate? So those kind of things would impact whether we can or cannot.
So Kareem and Paul, I think you bring up great points, and I agree with Audrey. Maybe Alex and I and Audrey and the leadership team can talk about it and see how it can be implemented. I also understand Larry's concern as well about having it on a regular schedule, because quorum will be an issue. But your point, Kareem, is absolutely correct, is that we do need to have these informational sessions public, and it'd be great to understand, like you said, to get into the weeds of things. So maybe Audrey, we can circle back on that. That'd be great.
Yeah.
Awesome. Well, thank you, everyone. Thank you, Dr. Cow, and thank you, Audrey and Amy and Tammy, for your support on this committee. Thank you all.
Thank you, Kareem.
Okay. I think we're here with Alex, Lawrence, Christian, and I don't believe David is joining today, but talking about moral character.
Good morning, everyone. Our slides will cover the accomplishments, ongoing initiatives, and training topics relevant to the moral character process. And I'll hand it over to our subcommittee chair, Alex Lawrence.
Hey, thank you. Just having a little difficulty unmuting. Happy to serve in the chair position of the subcommittee on moral character with the vice chair, Bethany Peak. this year. So looking at our 2022-23 accomplishments, we have and will continue to revise and review the admissions rules relevant to the moral character, of course, pending CBE approval to circulate for a second round of public comment. You'll see some more training topics later, but again, training on the unauthorized practice of law and conducting administrative reviews of the adverse moral character determinations and making final determinations with respect to the applications for determinations of moral character. I know that was more of a mouthful, but then when you go to the next slide, what you'll see in our in the current work plan is that we will continue to look at examining areas for improvement to ensure transparency and fairness. And then from a training standpoint, we're looking at starting some of these training sessions, looking at specific, say, case studies early in 2024. If you go to the next slide, please. For example, there'll be a presentation on governing law in the state bar court cases relevant to moral character determinations. And then when we met as a group, just talking about moral character case studies, I'm a big fan of discussing specific, say, different situations with details that many of us who serve on this particular subcommittee and bringing to the group for discussion. There has been, I would say, probably over the last 2 or 3 years, just even talking about like the ethical conduct, trying to get as much laser focus and clarity on what we're seeing in these particular cases that come across our desk, so to speak, and the staff presenting that to us. So if you go to the next slide. So some of the training topics, and definitely we are looking for more suggestions. The lawyer assistance program or lab, for as long as I've been on the committee, I've always found it very valuable to get updates on what the program does provide. So that's serving as a refresher. And of course, for new committee members who are not aware of the program, to get more details around that. And then rehabilitation related to moral character determination. So as you see there, we're looking for input from the group on additional topics, training topics, as well as edits and updates to the work plan that shared earlier. So let me pause there and see if there's any input, questions from the group. I see Mr. Reyes.
Yeah, this is great. Thanks for the plan as we move forward. This is more of a like a technical question. It may not be appropriate to answer it here, and we certainly can't get that answer today. But as we review these cases, we get to listen to the audio that happened, and it would be great to actually see the video and audio. And I know that for me, it's a chance to read a person better, get a sense of their body language and all that, because it's a little limiting just listening to the audio. Now, there might be reasons this can't be done. I remember we had this discussion before in the committee, and I think the video belongs to Zoom, and there's some problem with having it released fully. So maybe that's just something that could be looked at as in the months to come.
Thanks, Mr. Reyes. I don't have my notes from, say, past conversations on that particular topic, but did make a note of that about possibly, if it can be shared, the video, but would invite the staff for input on that, or even other committee members who may recall maybe discussions in the past on that.
Well, this meeting is going to be recorded and put up on the web, so there may be some confidentiality concerns about having recordings on Zoom, but seems doable technically. And I could see for in-person meetings, they probably would want to hire a professional videographer, and that will get expensive. But Zoom it's probably no extra cost to record them.
If I may, I think Vince is talking about the informal conferences. And so since those are confidential, they wouldn't be public meetings. There were concerns before about whether or not we could upload them just locally. And then one of the other concerns we had talked about in the past was the potential of just introducing any additional bias with having the video there. But it's something that we can circle back and look at again.
Yeah, but credibility is not just listening to someone's voice. It's seeing their facial expressions. There's certainly a trade-off.
I think we can definitely take a look at that because, for example, we provide the full video recording of the Jenny. This is when someone is going up for judicial nomination and they receive a not qualified rating and they want to appeal it. And so we have sort of a similar appellate process. We do provide the full video recordings of all of the interviews as part of that process. So we do have the capability of providing secure, confidential video recordings in other state bar settings.
Thank you.
Thank
That's
you.
helpful. We'll connect with them.
Any other questions or comments? All right. Well, great. Thank you. Turn it back over to you, Audrey.
No, I had trouble unmuting. Okay. All right, we're going to move to educational standards, including CS bars and law school council. Paul Kramer and Natalie.
Thanks, Audrey. Can everyone hear me okay?
I can hear you.
Okay, perfect. Okay, great. Before we turn this over to Paul, I would like to extend a special thanks. During this past year, we had an unexpected committee transition, and I wanted to extend a special thanks to both Jim Efting and Vince Reyes, who were not planning to act in the leadership roles that they eventually adopted very willingly with open arms during a very busy, heavy year. And having them as a team step forward with such enthusiasm on short notice really helped us to accomplish our goals. And that's a wonderful thing about this committee in general, the teamwork that you have, the commitment to your work, and there's an example of it in action. So I greatly appreciate you both. Yeah, and with that, I'll turn it over to Paul Kramer.
Okay, so for our just past year, what we achieved included presenting a law school performance report, enhancing the demographic data that's available as collected as part of annual compliance reports, continued as we always have to engage law schools through CS bars, the Law School Council, and the annual registrars meeting and law school assemblies, where we've focused on passing on to them information about how best to work with the bar. And this past assembly included some education on artificial intelligence and its potential effect on law schools. Another ongoing task is reviewing petitions for registration and accreditation, and the petitions for changes that are filed by existing registered and accredited schools. 3 non-performing schools closed during the year, and 1 school is on monitoring through probation, and we'll be talking about their case later in December at a special meeting. And we reviewed the minimum cumulative 5-year pass rate statistics from the accredited schools to see if they complied with that standard. 2 of them did not, and they were transferred to unaccredited status. Next slide. Our current work plan includes considering whether we should move towards mandatory accreditation for the unaccredited or registered law schools, as we sometimes call them. And that's something that's been on the work plan, I think, since I've been on the committee, and that was the end of 2016. It would require statutory changes. So it's just been sitting around, but I'm hoping that this year we will bring it to a head and decide if we want to pursue that route. If for no other reason than to get it off the list and eliminate any uncertainty for the schools that might be affected by it. It's likely to be controversial. It's going to cause some of our policy goals, such as public protection and protection of law students, to collide against the goals to try to increase participation in the practice of law and diversify those practitioners. It's not going to be an easy question to resolve, but I think it's time to tackle it. We also need to review our unaccredited law school rules. They haven't been updated in quite a while, and they have what some of us consider to be outdated provisions, especially in the area of enforcing compliance with the rules. So we need to revisit that, and there are no doubt other areas where the rules could be improved. A few years ago, we revised the accredited law school rules and created a new sort of category for those schools called jointly accredited status. We had in mind a 2-year kind of phase-in plan for the revised accredited school rules, and we're coming to the end of that 2-year period, and so we need to formalize the process for schools to be able to apply for that status. Of course, we've got our ongoing review of applications for accreditation, registration, and changes to law school programs. And we do periodically inspect law schools. Generally, it's a 5-year cycle. And so those reports will continue to come before us for our review and if necessary, action to improve the performance or the compliance of those schools with our rules. Next slide. So additions already proposed for the work plan would be review the items, I guess measures, Natalie, means data items that we want to include on the law school performance report. Is that right?
Yes, that's correct.
Okay. And also the review the annual report formats to make sure we're collecting all the data we need and I suppose to make it as convenient as possible for the schools to provide that data. And then a 2025 required disclosure under the Business and Professions Code. COPRAC has given us a referral just in the past few days, I'm told, recommending that we create a policy related to the use of artificial intelligence. That's all I know about it at this point, but everybody seems to be wanting to make sure that artificial intelligence isn't going to upset their universe, and it seems reasonable that we should be making that check as well. And then finally, to track the subjects that may be on a future bar exam. As you know, the Blue Ribbon Commission has proposed narrowing the scope of the subjects that would be tested on a future bar exam to see if that's going to impact our law school rules in any way. For instance, to the extent our rules specify topics that must be taught, well, obviously, or we may want to consider not requiring some of those topics if they're no longer bar exam subjects. Or we may still think they're important to a good quality legal education and say, well, you still have to teach them. But that's a discussion for the future. So next. Training topics, update from a regional accreditor. The joint accredited program, jointly accredited that is, in a nutshell, basically says that a California accredited law school who applies for and is given jointly accredited status will have a lower level of overview from the bar of its activities. The presumption being that the regional accreditor will be covering many of the same bases that we would cover, and it doesn't make sense, certainly from the school's perspective, to have to provide information to both the regional accreditor and to the state bar. When we adopted that, I think I, among others, said we need to keep an eye on this and see that it will be the case that regional accreditors will adequately look at, look out for our interests. And it's, until that's proven, we need to be very watchful. So part of answering that question will be to hear from a regional accreditor about how they would address our concerns as well as their own. And so that's a future. We do, I believe we have, or I think we have an item in the work plan regarding this. And my proposal is that we give it a couple years, because we know we don't even have any jointly accredited schools yet. But after a couple years, we need to schedule, a real hard look to see if our regulatory needs are being satisfied by the jointly accredited program. And then finally, some schools, both schools that are accredited or registered with us, and other schools, perhaps even Cal States or community colleges, have programs that do not lead to the granting of a Juris Doctor degree that would allow somebody to sit for the California bar exam. There is a state statute that seems to require the bar to be monitoring and perhaps even regulating those programs, which is something we don't do right now, except that we do review non-JD programs at schools we register or accredit, but only to make sure that they don't affect the JD program in some adverse way. So I'm personally in favor of getting the statute changed, so that we don't have that requirement on the books that we're not complying with because of resource concerns and other reasons. But it's a discussion we need to have as to whether we want to expand the scope of our review and regulation of law type programs that we don't currently regulate. And with that, are there any other suggestions for training topics or items we should add to the work plan?
And Alex, I try to capture what you were saying, so maybe you can clarify on that. Yeah, your addition to the work plan.
Yeah. I appreciate it. And so this sort of relates to the last point in your slide, Mr. Kramer. So for the full committee, in consultation with Dr. Cow and Mr. Kramer and Audrey, I want to add one item to our current work plan, which is to explore ways in which to incorporate the CAPA study and the BRC recommendations into our existing rules and policies for our existing educational standard. Back in 2017, right before the pandemic, and some of us may recall that the California Supreme Court decided to keep the cut score at 1440 in view of the final report on the 2017 California bar exam standard setting study that the state bar had conducted and we have reviewed. At that time, the court asked the state bar to, among other things, examine whether the student metrics, law school curricula, and teaching techniques might account for the decline in the bar exam pass rate. The court also asked us to, at that time, to consider how the data that we gathered in the standard setting study might inform us in our efforts to improve academic instruction for the benefit of law school students preparing for the bar exam. But since then, little has been done to address the court's directives. And as the pass rates continue to be at historically low, we as the committee should really look into ways in which to help these students improve their legal education. And in view of the CAPA study, recommending that the bar exam focus on certain exam topics that actually reflect the current practice of law in California, as well as the BRC's recommendation to modify the bar exam to better focus on knowledge, skills, and abilities. This is really the time for us to consider ways to incorporate these recommendations into our educational standard. And so I would like to propose that we'd add a new item again to our work plan, which is to review our admissions and educational standards under Title IV of our state bar rules, among other things, to see which rule, policy, or procedure can be potentially modified to implement the CAPA study or the BRC recommendations. And as part of that process, we will also look into which aspects, and I think Mr. Kramer touched on this, which aspects of the CAPA study or the BRC recommendation we can realistically incorporate and implement, and also places where we can equal the playing field and promote diversity, equity, and inclusion for applicants from all walks of life. And so with that, I will open it up to the full committee for comments. After that, I would like to put Paul and Natalie, deferring to Dr. Cal as well, in charge, to be in charge of this effort. And I, as well as any member who is interested in participating in this initiative, will work alongside them to report back to the committee about our proposal at the next meeting.
Your timetable is probably ambitious, given the holidays, and I think staff would probably say until we know what's going to come of the BRC's recommendations, we probably we may be premature in trying to design something, but it's an effort that I support over the longer term, and of course the CAPA study is kind of an independent measure of where new lawyers tend to concentrate their practices. So that's useful information without consideration of whether the BRC recommendations go anywhere. Resources, though, Audrey, Natalie.
And let me just quickly respond to that. I think that's a great idea. And we can do this in phases, by the way. I think the first phase would be just to explore places where changes could be made. This is not to say we know what the substance is going to be, but at least at a minimum, we should know if changes were to be made, where do we start? So just finding the starting point, I think would be useful. And certainly we would, wait until the court has decided what it's going to do before exploring the actual substance. Hopefully that, and I agree, the schedule may be a little ambitious, but I do think we have at least some bandwidth to understand where we can kick the tire.
And Alex, I think with your call to action, we can make sure that we lay a foundation so that the committee is educated and ready when the court makes a decision, understanding the history up to this point, how that compares with the rules today, and then we can marry that with what we learned from the Supreme Court.
Yeah.
And also at some point we need to include the law schools through CS bars in the brainstorming of all this.
And speaking of CS bars, am I right? I thought the trustee is considering whether to keep CS bars for the long term I don't know what the status is and whether that is the accurate assessment, but I will defer to Audrey in case if she has any comments about that.
It's a standard review of sub-entities that the board does. I think it's Leah might know. Is it every 5 years? That is one of the sub-entities along with a long-ish list for next year that will get reviewed by the board.
So has the review been undertaken, or is it to be
It's going
undertaken?
to be undertaken. So it's not
Okay.
it's nothing special about CS bars. There's several sub-entities that are up for review.
Including the law school council. I think there are 3 law school related sub-entities. Law school council, CS bars, and what is the other law school?
The assembly, are you thinking of?
Perhaps I can pull up the memo.
Yeah.
And then the related Board of Legal Specialization as well.
Yeah.
So we should take nothing from no information from the fact of the review. It doesn't mean that they're under any sort of threat. It just means that
It's timing.
it's good government is to ask yourself whether something is still relevant, which doesn't always happen.
Right.
So there's no recommendation in place, at least from the staff, about whether to keep. Okay.
No, it's a phased recommendation, and I believe that part of this go around, there'll also be a review of the Council on Access and Fairness, as well as COPRAC, the group that works with the rules of professional conduct. So this really is just it's a good government check that happens every 5 years.
And I suppose even this committee will be reviewed, right, Leah?
Statutorily required committees are not being reviewed. So the review is applicable to all sort of discretionary committees of the state bar. So no.
Gotcha. Thanks. Okay.
Oh, can I make a quick comment real quick,
Sure.
Paul? So Alex, I love your idea. I'm in full support of it. And let's see, like, what Pod mentioned and Audrey about, what are the steps that we can do to act upon it.
Thank you, Mr. Chair.
Okay, Audrey, I think you have the training calendar next.
I do. Well, I was just waiting to see if there's any other Ed Standards comments before I share again. Okay. So this might be something we can talk about now about how to juggle all of these, the 2024, and maybe that speaks to Paul's comment about longer meetings. We only have so many meetings. So where do we prioritize the trainings? And also I think a conversation that we need to have as well is how do we prioritize all the work that we have in 24, especially if we're going to have what I talked about at the beginning. We'll have the overarching recommendations coming back from the Supreme Court early in 24 that could affect a lot of the committee work. So this is what we've tentatively put in terms of narrowing the training topics. And then I think we probably can talk about maybe in our January meeting, the staff will come back with some of the work plan changes, and we can talk about the overall prioritization of all the additions that we have as well. But any comments on this tentative training calendar? And I know this should be lawyer assistance. Is that right? And this is, oops, sorry. This is also including the drafting, Alex, here. Let me write that.
Thanks, Audrey. I personally would love to hear about, or at least receive training on this specific topic earlier than August. I don't know if anyone else feels the same way. But if we can do it, before the July bar exam, I think that'll be helpful in case we do want to take or make any changes. At least that could, become effective for the next February bar exam. So that's just my personal take.
What do we think about swapping April and August? Anyone, staff or subcommittee?
Staff, it's fine.
Would that work, Alex?
Works for me. Dr. Cow, is that okay with you?
I agree with you. I think that'd be important to be able to discuss that before the July bar exam. So thank you for bringing that up, Alex.
Vince Reyes has his hand. Vince?
Vince, you're muted.
I have to do that at least once every meeting. But I had a question on the December Lawyers Assistance Program. Is that, because we're going to talk about this already in the moral character. Is this specific to ed standards, or is this something that can be combined?
No, this is across all the subcommittees.
Oh, okay. I got it.
Yes.
Okay.
Oh, so sorry. I understand what you're saying. Yes, this is a full committee trainings.
Okay, it's clear. Thank you.
Good question. So then we have two exam. I mean, I don't know that that matters, but we'll have two exam related trainings kind of in back-to-back meetings. But
I don't know if this is an appropriate time, and please tell me if it's not. I just wanted to make sure we could engage in a little bit of discussion about prioritization, because if the committee, and I hope you are, and I think the intention is to take on the question of unaccredited schools and mandatory accreditation, if the court comes back with approval of the BRC's proposal, and if the court also came back with approval of the PBE recommendation, that is a really significant amount of work, just those three items. And so when I'm looking at this presentation and hearing the discussion, there's a lot of great intentionality about having work done in all of your different buckets, but it may be appropriate for CBE and staff to consider that next year, and maybe 2025 as well, are years where you're really focused not on all of the different areas that you work in, but rather all leading into some of these really major initiatives that are going to change the landscape of admissions, in California. So I don't know when the appropriate time is, and we don't know, of course, what the court is going to do. And maybe the right thing to say is when the court does deliver its verdict, so to speak, on these issues, then there might be a need to reconsider the work plan. But I just wanted to throw out there that this seems incredibly ambitious, and some of these I think are much more significant and timely than others. And I wanted to make sure there was some consideration of that.
Can I ask, are both of those initiatives now in the court's hands?
No, the PBE, it should have gone this week. It's not. It'll go next week. And my understanding is the court wants to consider both the BRC and the PBE together.
So probably the earliest they'll consider it would be January then.
Yeah, that's probably not likely either. I think February is probably more likely, but I don't know.
I know that Alan, you have your hand raised, and then we can maybe talk about the prioritization. Go ahead, Alan.
Yeah, my point is very minor compared to this. I was just going to suggest that the LAP presentation in December, can that be combined with moral character rehabilitation? Because that's always one of the options anyway. When we talk about moral character, that would free up the December training for something else. Just a thought.
Christian? Tara?
Yeah, that's fine.
Okay, that's good. That gives us another slot because I think we have additional training topics identified. So that's good. Thank you, Alan.
So this is Michael. Leah, thank you so much for bringing that up because, like you said, that those are the major issues that are coming down the pipeline for our committee for 24, 25. So I guess if that's, if that's the case, then as a committee, we will need to look at, how to prioritize. Obviously, we'll have to pivot depending on what the court, when and what the court decides. But I guess the question is that, and this is also a minor point that I'm going to bring up, is that is the review of the non-JD programs time sensitive? Because if it is, I understand if it's not, should we move some of the other items that have heavier weight, such as TA and exam question that Alex talked about? Should we move them up so that if what Leah alluded to, maybe February, March is when the court decides, we would be able to discuss that? And I'm just bringing it up as a committee. I'd love to get everyone's input since Leah brought up a great question about prioritization of our agenda for the upcoming year.
I support that.
Audrey, is that review of the non-JD programs, is that a time sensitive issue at all?
I mean, I think, go ahead, Paul. Sorry, were you going to talk? It was what Paul was talking about in terms of in the statute.
Well, yeah, I don't know. I mean, we have been not consistent with the law for probably for years, probably more than a decade. I forget when it was enacted. I want to say the late 2000s, but that is a vague memory. And so I don't personally see it as that critical.
Starting the conversation about mandatory accreditation would be something you'd rank higher than that, Paul.
Yeah, I think so. Just because it is fundamental to our our regulation of schools that lead one to be able to take the bar exam, and it'll should get juices flowing too.
So maybe that's something in terms of CBE timing, Dr. Cowan, Alex, so we could talk about mandatory accreditation discussion and what that would possibly look like for implementation at the January meeting.
Yeah, and today Michael was planning on having me kind of run through the work plan, so we could to make that decision right now before we've all seen all the other things that are on the work plan that we didn't mention to this point would probably not work very well. We need to see the full panoply of the items, and even trying to prioritize them today might be premature because we may need some time to think about them.
Okay, I think that's fair. And I think we can go through the points of consensus in the work plan and then either have some sense of prioritization or really focus on it at the January meeting. How does that sound, Dr. Cowan, Alex?
That sounds great. I think that obviously this is a working meeting for planning for 24, 25. So I think that, yeah, we do have to have everyone look at what are our objectives and what carries heavier weight. So that sounds great, Audrey.
Okay, well, we're ending the staff slides with having room in December for another training topic. So that's good. So that's something we can bring back. And I know you want to go to the consensus document. Did you want to?
Yes.
Do you want to do a 5-minute bio break, or you want to just move ahead?
Yeah. If it's okay with everyone, it's 10:30. Maybe we can do a 5-minute break and then we can come back and talk about the points of consensus. Is that okay with everyone? Yes, it looks like yes. So it's, yes, I see a lot of head. Yes, so it's 10:30. So we will all come back at 10:35. Okay, thank you.
Can folks turn their cameras on if they're back from the break, just so I know if we're ready to proceed?
All right, it's 10:37. I apologize. It was a quick break, but we have a lot of items to discuss today. We're still on agenda item one still. So what I wanted to talk about was, it's called the points of consensus. And, I'm going to turn it over to our immediate past chair, Paul Kramer. Under his leadership last year, when I was the vice chair, Paul had this incredible idea of points of consensus, so that this way, moving forward year to year, we wouldn't be having to repeat what we did last year, but we understand as a framework. So for the prior CBE members, this is a review, but we haven't talked about this agenda item in months. And then for the new members, I think this is a good foundation to have a better understanding of what the CBE does. So I'd like to turn it over to our immediate past chair, Paul Kramer.
Okay, there we go. So this is the document that was on the March agenda, which is the results of our planning session last December, generally called the points of consensus. And I'll try to scroll through it. You have a version you have the same document that's attached to the chair's report item on the agenda. So you can use that as well if you want to scroll ahead or lag behind what I'm showing. So the beginning just makes the point that these points of consensus and agreement are not binding on the committee or future committees, but our preference is that we should try to honor going forward, in the name of consistency, predictability for both us and in some cases for members of the public. First was a list of our roles and responsibilities. I'm not going to read through all this, but I will, as we go through this, highlight some parts in more detail. Is this large enough for everyone to see it on their screens?
It's fine for me.
Okay, good.
Looks great.
If you're looking on your phone, I apologize, but there's really no way to make that work. So these are our policymaking functions on the first page. The regulatory functions slide over onto the second page. You've got admissions, oversight. This one here highlighted in green, I think needs to change. And what I'm going to do today, I propose to do, is discuss with you some changes that we might want to make, and then we can just bring it back as a consent item in January for everybody to see if I've properly recorded what we agree upon today in a revised version that I'll produce for then. The reason this item in green has to go is, well, or may need to go. This was premised on the idea that we were no longer going to be considering testing accommodations. And so what was built into the rule change that would have made that happen was the idea that we would then start auditing in some way the staff decisions to get a sense that they're, whether they're being made consistently over the various cases, and whether the proper standards are being applied, and things are being done in a timely manner, et cetera, et cetera. But now that we still participate in that process, I'm not sure we need this. The proposed rule still includes a test, a kind of an auditing function that wasn't taken out when the part where we were not going to be considering appeals anymore was removed. So I just wonder if I don't think we need that extra burden for the Testing Accommodations Committee to both be considering real appeals and then also auditing other actions of the staff, because by seeing the appeals that are raised to their level, I think they get enough information to have a sense as to whether the process is working properly. But I throw that out as a question, rather than just imposing my opinion, which would be inappropriate. So does anybody think that we should continue to look into some sort of process for generally looking at the full scope of the testing accommodations process? Or is it enough that we are going to continue to consider appeals at the subcommittee level? Let's see, should I on-share so we can see? Anybody have a thought? Raised hand. Ashley?
I think one, bless you, Amy. And then two, I think with the trainings that we're also doing, both on our side with testing accommodations and also with the application or the actual the ones regarding the testing accommodations applicability during the actual exam for private testing and things like that. I think we're kind of handling a lot of that. I don't know if we need additional with the subcommittee kind of handling most of it, but that's my opinion. I don't know if anyone has any more.
Does anyone disagree? Okay, I'm going to call the consensus to delete this paragraph here. And we'll just leave the general topic of oversight, because that is one of our jobs, I think, in most of our views. The next one, we had agreed in the past to go on public comment to limit it to 3 minutes per speaker. This is the policy that was adopted by the Board of Trustees. So, Dr. Cow, I would recommend in the future that we go back to 3 minutes, unless somebody disagrees.
Understood, Paul. Thank you for that reminder. I appreciate it.
Okay. And then this one here, let's see. Oh, we are. Sorry,
Paul, I'm sorry to interrupt. On the 3 minute rule, is there any discretion there if we have an extraordinary long?
Yeah, see the next sentence. We can reduce it to 2 minutes per speaker if there's so many that we couldn't fit them all in 2 hours.
Okay.
Yeah.
Paul, can we go back to sharing screen?
Oh, sorry. Yes. Yeah, I forgot. Oops, I almost shared my inbox. Okay. So yeah, sorry, Alan, it's right here. And then we've, the next item, we're trying to eliminate unnecessary discussion of items where we can simply present a written document and see if anyone has any questions. And we achieved that recently with Dr. Cow's change of the agenda to have consent items or consent items. So we still can discuss anything we want to, but we won't go through the motions of having somebody make an oral summary of a document where nobody really has any need to talk about it. We will receive the information more efficiently that way. If we do run into really busy agendas where we're afraid that some people are going to have to drop off at the end of an agenda, what we can do is just postpone the consent portions till the end. And so if we lose a quorum, generally those items are informational only. We won't really have lost any time, that we can dedicate to items where we have to make decisions. And I'm not sure, I haven't run this by council, but we might still be able to keep the meeting going without a quorum, just to present the information. And then others who had to leave can go back and look at the Zoom recording and be able to see what was said. But again, no action would be able to be taken. But in most of those cases, none would have been expected. Now to the role of the work plan. It used to be, and Alan, you'll certainly remember this from your previous time on the committee, we had individual subcommittee goals that would be on the agenda every meeting, and we would look at those, see if we needed to add or subtract anything, mark some as having been completed, or change the expected timing of those goals. Staff wanted to combine at the beginning of last year everything into a single document, and they already had to give a work plan to their managers at the bar and to the Board of Trustees for the admissions function. So Dr. Cowan and I said, oh, that's fine. So long as we make sure that all the items that had been in the subcommittee goals are also in that work plan. And we got everything put together in the plan, and we'll be looking at it in a few minutes. What this says is that we want to have it on every agenda, not so much to go into it in depth, although it sounds like we will need to do that in January, but in case we discover that there's something we need to add to the plan, if it's not on the agenda under the Bagley-Keene rules, we can't take any action to add something or subtract something from the work plan, for that matter, until the next meeting. And that just seems less effective, efficient. What if we have an idea, let's just get it on there and create the opportunity for us to do it and not have to put off the action of adding it to the plan until the next meeting. But for most meetings, it will just be a placeholder. We don't have to talk about it unless somebody has a question or an addition or modification or subtraction to make. And then the next item talks about our receiving information from outside our orbit about things that may affect us, the Board of Trustees actions especially. But there could be other things. And doesn't say this here, but this is meant to be a communication from us to staff that we expect them to be looking out for these events and bringing them to us in their, say, the director's report, for instance. And then sometimes we get a lot of information, and even if it's published, say, a week before our meeting, I'm on F here now, the yellow highlighted item. It can be a lot to take in. It may be proposed regulations or bar rules that are, have a significant length. You may need more time either to consider something, or I'm sort of famous for coming up with all kinds of questions about rules and proposed changes. We may need to have more time than just the one meeting to be able to resolve something. So what this is telling you members is that if you feel like you need extra time, you should feel free to request it. And also to tell staff that when they're planning things, because what we do generally goes to the Board of Trustees if it's a regulation or a bar rule change, that they need to keep in mind that we may not be able to process what they've given us in one meeting, and so adjust their timelines accordingly. And that's an important point I know I wanted to make, and I think some others definitely agreed to that. So for new members, especially, be prepared to bring your concerns, your questions, your proposed revisions, say, to a rule to the initial meeting, but then delaying the final action till the subsequent meeting allows staff to either research or make revisions to the draft so that we can see a new final version for our consideration at the subsequent meeting. Let's see, and then G here simply saying we need to make sure we allow ourselves enough time to fully and properly consider items that are presented to us. If we cram our agendas so that we feel we just have to make a decision and move on because we've got so many other things to deal with to finish up for the day, that's not something, that's not ideal, certainly not our goal. It relates to the discussion we were starting to have a little earlier about maybe we need to have more 2-day meetings, or at least more than 1-day meetings, maybe a day and a half or whatever. And then we, in H, we express our preference for in-person meetings. Although I'll notice that the Zoom recordings of our meetings are very useful if you need to go back and see what was said. I assume they're also helpful for Devin when she's preparing the meeting minutes of the meetings. Expectations of all of us. We all have roles. The chair and vice chair, do things like make sure that we try to assure that our agendas are, organized to meet all of our other requirements. Keep an eye out for events that happen in between meetings that should be reported to the group, both by consulting with staff and just kind of keeping your eyes and ears open. And those sorts of things. Subcommittee chairs. First of all, or subcommittees in general, and then the chairs and vice chairs. As I said earlier, if you're on a subcommittee, it means the rest of us are expecting you to really focus. To the extent you have to limit your focus to items on the agenda, make sure you're focusing on those items on your subcommittee's agenda, because to the extent the others of us have to, maybe provide a little less attention to those items, we're relying on you to make sure that we're informed to make a proper decision. One of the things subcommittee members do is they participate in some subcommittee business that occurs outside of the full CBE meetings. An example is school inspections under Ed standards. Here, we're saying that volunteers to participate in the school inspection committees would come first, but not exclusively from the Ed standards subcommittee. And that's different for moral character, because we had a discussion towards the first part of last year about how much background experience and people participating on a moral characters appeals panel should have before they can serve on the panel. We didn't want somebody coming in cold without some experience in how the things were conducted, and kind of a sense of what our values are, so to assure consistency in the application of those values to the cases. So we we don't have a more detailed description of what would qualify people yet, and that's on the work plan to create that. But there, don't expect to just drop into a moral character appeals panel. We want you to have observed some first, so you're up to speed. And then, so this D about testing accommodations, if the rules change, we'll have to change to just say that they're considered by the examinations, rather now it's the new testing accommodations subcommittee exclusively. As far as subcommittee chairs and vice chairs go, we want you to be a filter to the extent you can to help review staff reports before they're posted for things like clarity, consistency, and the inclusion of all the information we need to inform our decision. You know, staff, and I found this when I was working as staff for a government agency, you can fall into the trap of thinking that everybody knows everything that you have in the back of your mind. And so you don't necessarily put all that information into the staff report that you prepare. And that's where another set of eyes who is, not so endowed with all the knowledge that you have can help you spot areas where you should, add some information to the report, or maybe identify some questions that are likely to be raised by a member of the committee and have you preemptively address that in the report. So I know I do this with Natalie, when you can review the reports prior to their publication, you can help improve them many times in those ways. And then the second aspect here, it's meant to say that of late, we've kind of fallen into a tradition where the subcommittee chair presents the items on the agenda for that subcommittee. But this is to say that that's not required. So if you might want to be a subcommittee chair, but may not feel comfortable or want to take on that burden, and this is to say you don't have to, it's okay. Moving down, I'll skip the representatives on external commissions, committees. I think we're done with that for the moment, except for CS bars. But finally, the expectations of members. When a rule proposal is being formulated, staff of late has been creating working groups with the staff and 2 or 3 members of the committee to go over rule amendments before they're presented to the full committee. Here, the goal is that when you're looking at these as one of those members on the working group, look for clarity, consistency in the proposed rules or standards, and the same thing regarding the staff report that I mentioned for the subcommittee chairs and vice chairs, that they're being clear, answering likely questions and that sort of thing. The corollary point is we don't expect you as a member of these working groups to be deciding things for the committee. Just, the committee should be able to exercise its own judgment. Your role is more to make sure that all the information is there for us to make a judgment. One place where I know the lawyer members especially can help is with reviewing the language of the rules to see if they're consistent, if it's clear. You'll see a small example of that later today when we go over the Chapter 6 rules. I wasn't on the working group, but when I reviewed them this week, I found some things I thought could be clarified. And so I had a call with Tammy yesterday to talk to her about them, and she's prepared a summary of the changes she has agreed to on the basis of my input. And you'll see that later today. So that's especially helpful. It also makes it more likely that we can actually get through the a rules package in one day if you don't have people like me at the last minute coming up with suggestions, if they're worked out in advance. Candidates for additional discussion today, possibly. We receive from Devin copies of written public comments that are submitted before our meeting. And then they just, as far as the public goes, they never see those compilations. They can make a Public Records Act request for them, but that requires staff time to go find the documents and then individually send them to the requester. I wonder, does anybody see any value in creating a repository that's accessible to the public on the website without them having to make a Public Records Act request? And then before I open it up to comments on that, let me ask the second question here, which is, do we need to do more work formally describing how somebody who wanted to participate in moral character appeals would get themselves trained to be able to do so? Or just sort of leave it to the judgment of the chair of the committee to kind of work out an informal process where they would identify themselves, and then they'd be added to as observers to one or more of the appeals efforts. I will stop sharing so I can see. Any thoughts about those two or any of the other items that are on the points of consensus? Kareem?
Yeah, I just wanted to, first of all, thanks for walking through that. Paul, you're very in depth, and I love how you look at this holistically and kind of some elements that are really critical to the service that we provide on this committee. When you brought up the public comments, I was under the impression that those were posted online and linked. I know we get them attached via email, but there might be a way that we should be able to upload them and then provide that link for us as members to see. And I don't know Bagley Keene's requirements of those to be noticed. I know there's like Brown Act, but we're not subject to. So if there's a way that it could be done that way, I think it'd be a lot more fluid and accessible. Because sometimes for me, I'm reading them in the moment, but if I want to refer back to them, I'm hunting through emails. So I could just say it's, I'm glad you brought that up, because I think that's another critical aspect of our work, is that people do send us very in-depth. And like I said, I serve on other committees, but this committee, I get really in-depth policy-driven comments that are really, for me, it's a good learning opportunity, because sometimes I'm not in this space as much as I would like to be, but it really gives me another viewpoint, because I am a public member. So if there's a way that it could be streamlined and uploaded and centralized, I would love to see that, and I'm glad you brought that up. So that's my only comment on that.
Okay, it just occurred to me we could simply add an item to the agenda after the fact, the posted agenda, and link to that final file that Devin sends us that has all the public comments. Probably need staff to look into it, make sure there aren't some kind of privacy concerns or something, but Ashley?
I think you just addressed my point, but I agree. I think even if we can include like a link on, because we already put our agendas up and have those easily accessible to public public viewers. So I think including a link on just those agendas would be the easiest way to do it. That or having like a dated separate page where people can go by date. But since we already have the agendas up, it seems like the easiest way to include those. Yeah, I agree.
Dr. Cal?
Paul, the question I have and actually is that, should we ask council to weigh in on this? Because, I mean, the public records request is there for a reason. I am supportive of the idea that it'll be nicer to have one bin where we could look at everything ourselves as members, but at the same time, the public can see what other public comments are. But my question is, do we need council to weigh in on this?
Yeah, and not today. I'm simply suggesting we make it a work plan item. So it sounds like nobody disagrees with that idea and looking into that. Okay, so what about the moral character aspect?
So staff did draft a document that kind of outlined training requirements last year, and we had reviewed it with our subcommittee chair, who was Dolores at the time, but she felt it wasn't necessary. So it's something we can revisit with Alex.
Okay, do you want to do that? And maybe report back a future meeting?
Yes.
Okay. I guess we should put it on the work plan just to be complete. Okay, so did anybody have any additions based on this? So we'll go through the work plan next. Nobody has anything else. Okay, let me switch gears. Work plan. This is smaller print. Is it going to be, let me get to the top. Is it going to be okay? Anybody having trouble?
Oh, can you share the screen?
Oh, I thought I did. Sorry. Oh, that's right. I took it down. Yeah, that. Okay, same question. Readable? Okay, Ashley says okay. All right, so like I said a few minutes ago, this is the document we use to keep track of all that we're doing. Some of it's more staff driven, some of it's more a reflection of our goals, but we combine them all in one place. So one of the things we need to do, who's on staff has drafting control of this document? Is that Amy?
Amy has been
Okay.
revising this document.
Are you here, Amy, to hear all these thoughts?
I am. I'm here.
Okay. So first thing you need to do is change some of the subcommittee names.
Yes, will do.
Okay. So these are, it comes in a different order than we normally talk about our committees, but that's fine. We'll just use that. So on moral character, we have two kinds of assignments that we list under each committee. One-time assignments you see here, and then you see the beginnings of the annual assignments at the bottom. So the one-time assignments are, let's see, the rules revision is completed. Is that correct, Amy? No, we had a second round of public comment.
It's going to come back to the committee in January, Paul, after the court rejected it.
Oh, okay. So can we change the date to January I don't propose to micromanage the wording of these, just leave it to Amy. But maybe we get rid of the part that was completed in March and just talk about what's coming up in the future, Amy. Does that make sense?
Yes.
Okay.
And Paul, just as a background, these were not revised because we're, as part of the planning, the idea was to determine what of the planning was going to get incorporated. And so we were going to incorporate what resulted from the planning session into the new work plan.
Okay, and I guess I misspoke, I think, when I said there were two types of assignments. I think there's actually a category for what I would call wish list items. Where we write down things we would like to do. Well, maybe there isn't, but there should be. I'm sorry for the scrolling. Um, because we also want to use this document to record things we'd like to do, but we're either resource constrained or
Yeah, that was a
or-
list parking lot items.
okay, yeah. So we'll have some of those. For instance, my example would be in the Ed standards, the idea that we're going to look at how joint accreditation worked in a couple years after it's been up and running for a while. So obviously there's nothing to do right now, but we want to write it down so we don't forget it. And I think this is a place, Amy, where reviewing a recording of the Zoom meeting is going to help you a lot as you go to try to revise these. So we had a rule which wouldn't let a attorney who is not in good standing in another jurisdiction from even submitting a moral character application. And we proposed a change to that. That is that went to the board? Did they send it on?
Yeah, this is,
Oh, go ahead.
it's going to be incorporated in the other rules revisions for moral character since they're coming back.
Oh, okay. Anyway, so that's, I guess that's still not completed, so it stays there. And then we have, these are annual assignments. We do trainings, and these are all, we're going to do rehabilitation and LAP again, so we wouldn't call those completed. Anyway, figure out what's right about the status, Amy.
Yeah, we revise those before each meeting, but like I said, the reason it didn't happen at this meeting is that we wanted to solidify the planning document in order to come back and reevaluate the work plan.
Okay.
We'll do this
Yeah.
before the next meeting.
Yeah, so we'll definitely will be on the agenda, and we'll but it can be something we can review in advance and then
Sure.
come with our comments.
So
and
yeah,
additions.
Paul,
Okay.
the idea then is at the next meeting, we'll bring, for example, the new training topics that we decided will be on the work plan. We'll bring, some of the new initiatives that we discussed, and then I'll incorporate like the parking lot items that we like you just suggested. So we'll have two documents: the new work plan and or like the new revised work plan and the parking lot items, and we could discuss those.
Okay. And you want to keep the parking lots in a separate
Yeah,
document?
a separate document that's not a
So it doesn't overload to your overlords?
yes, will do, or us.
Okay. Okay, so then you don't see my cursor at all, do you?
Oh, I do. You're hovering around conduct
Okay.
and review.
So watch my cursor, folks. This next item is just the usual business of moral character, making determinations. And then under examinations, which is now it's still examinations. Yeah. Okay. So we've got testing accommodation rules. We're waiting to hear from the court on those. Correct?
Yes.
Okay. Admissions rules, those are at the board or at the court?
The admissions rules, I'm sorry, I have to put on my glasses again. This is
this is Blue Ribbon, sorry.
today.
Yeah.
Mhm.
Well, no, today is chapter 6, I think. Okay, and then we've got examination grading rules. We completed those apparently. Anyway, those are on the list. And I apologize that this presentation is a little disjointed, but my purpose right now is to show everyone what's already on the list. So if they have something that they want to add or think they need to add, they can see whether it's already there. This one about developing recommendations regarding the components of the bar exam, that's going to be informed by what the court does with regard to Blue Ribbon, correct?
Well, that first item there, it's going to be informed also by the Access Flex grant, you know, the pilot study that we're doing.
So we're working on it?
Yeah, we did the pilot study. This is the experiment that we just completed in October, and we're actually going to be doing the actual experiment in April and May of 2024.
Okay, so we won't hear back from about the results probably until the end of the year.
Of 2024.
Okay, yeah. Okay, this one we talked about in the staff slides, examining testing accommodations to see that they're working well. And okay, we have decided to eliminate the essay portion of the first year law students exam. And if, just by definition, when we've done that, we have to reconsider the passing score because the landscape has changed. So that's on the list already. Diversifying the grader and exam developer pool is there. And then we have training. And these are both set for training. And then one of our regular tasks, which will occur again tomorrow, is to approve questions for the bar exam. And then annually we review reports on the bar exam and approve draft reports to the Supreme Court on the bar exam, I guess not the first year law students exam. And we occasionally consider petitions asking to waive some of our policies, procedures, and rules. And then, of course, definitely ongoing is reviewing testing accommodations requests. Anything anybody wants to add to either moral character or testing accommodations? Let me see if I had any here. Oh, let's make sure we include how we select exam drafters, question drafters in the presentation on the drafting process.
Yes. Yeah, we discussed that as part of the planning. We definitely will add that.
So just make sure it's clear in there that that's a part of it. Okay. Okay. Oh, under moral character, investigate whether we could be able to view video recordings of the blanket on the term for the meeting with the applicant.
Admin reviews, right? Or admin hearing.
Well, no, when we review the record.
Informal conferences.
Informal conference, there you go. And that's all I had from earlier discussions. Anybody have anything else? Just speak up. I won't stop the share. Okay, I guess nobody. Next is, now this is called examinations. Formerly was called operations and management. And this is a general rule revision assignment. If you consider us to have incorporated all, specific rule revisions in other places, Amy, and there's no need for this broad kind of general line item, we could take that out, I suppose. And let's see, we're still working on admissions rules. We're still working on this one?
Yes, we are.
Okay. And eligibility, we're still working on.
Yeah.
And so we're still, this next one, we're still reviewing. We're going to recirculate a second time. Okay. We completed our input on examination fees.
Yes.
Okay. And this was on the list of things to look into, evaluate whether to phase out handwriting.
Correct.
Reciprocity. So the BRC did recommend it, correct?
They recommended it, but they also recommended, that the court also investigate and explore with more specificity some other factors related to reciprocity. And that's where the committee it would be helpful for the committee to look at some of those factors, such as what happens to non-ABA
right.
students in California. How do they fare in a reciprocity coordination with law schools and other states that do not recognize non-ABA students? How do we work with states that, we're
Yeah,
not
there's more to it. So we're not done.
jurisdiction. Yeah, there is a lot of other policy issues that need to be explored. So
would it be fair to say that if the court decided to go through with it, we would also draft whatever rules needed to be in place to implement it?
yeah, I think here the ask is to explore what a recommendation would look like, right, to the court as part of that. What policy decisions we would want to make.
But yeah,
Okay.
there would also be rule revisions related to reciprocity.
So are you expecting to bring something back to us in January? Or?
No, I think the idea is to at least start this discussion and exploration itself. We don't know where the court has landed on this, but I think they're going to want some.
Well, if they decide not to go forward with it, then there's nothing to do, right? So should we wait until they decide before we, January already sounds like it's going to be a bit busy. So I would think this could wait. Would I be wrong?
Yeah, let's find out. It sounds like
Michael, I don't want to step on your toes, but
maybe we'll change that to the April meeting, Amy.
okay, let's wait till April meeting, because it sounds like we're going to know more in January and reevaluate and reprioritize everything anyway.
It may be that we just identify for the committee what the Supreme Court action was, if it's taken by the time of the committee meeting, and maybe solicit volunteers to help work with staff.
Okay. All right. And then the exams committee also considers waivers of committee policies, procedures, and rules. For instance, the 5-year rule, and that sort of thing. And Chapter 6 notices will go to this committee, correct?
Correct.
In fact, do we actually list Chapter 6 notices? Should we?
In this item?
Yeah, because this committee is the one that gets them, right?
Mm-hmm.
Might be
But I
good
believe
just to,
that falls under exam-related policies, procedures, and rules. Do
okay,
we need
yeah.
to spell it out?
I don't know. Might just be good to call it out because it's not so much a waiver as an appeal of a Chapter 6 notice and sanction.
Mm-hmm.
Doesn't hurt.
Okay. I think also this includes waivers for Rule 4.17 as well.
5-year rule. Yeah.
Mhm.
Okay, and then we have some reports we review. This committee reviews on the bar exam. It's overlapping with the testing accommodations committee, I believe. I thought they were there as well.
Mhm.
Okay, I'm not gonna scroll like crazy. Okay, so any additions to that list? Oh, what about this is I have two. One was the looking into 2-day meetings, more, extended meeting time to allow us to consider all the business that we seem to have sometimes. Do we want to add that to the list? Sounded like people were interested earlier. And then Alan will remember when he was last on the committee that we received information about the budget periodically. You know, how the balances were doing in the admissions fund, expenditures, costs of exams, and then that stopped. And some of us, me included, complained about that and said and in fact, it's in the consensus principles, words to the effect that to do our jobs correctly, we need to be able to have a sense for the budgetary constraints that might exist on the bar and especially the admissions fund. So I don't see anything in this list that refers to our continuing receipt of that information. We were involved last year because we had to weigh in on the proposed increases to the fees. But I certainly was hoping that wasn't a one-time event, and that we would continue to receive more information. We're not saying that we're going to decide the budget, but we should know about it and how it's doing. So can we add an item, assuming nobody objects, to somehow encapsulate that concept that we'll receive periodic reports on the state of the admissions fund budget and expenditures and receipts?
So if I can interject here, Paul, this is Donna. I thought what we had indicated that we would be doing is including in any agenda item for CBE where we're requesting adoption of certain rules or changes in procedures, that we would be including a fiscal impact statement, much like we do for the Board of Trustees, which would indicate to the committee the impact on the admissions fund by adopting any particular direction that may or may not be recommended by staff, but that the Board of Trustees is the one that has authority ultimately over the budget. And so I don't think we were going to be sort of presenting budget information to the committee in the same way that we had in years past.
and hadn't been until for a couple of years until last year. You don't want to do it. I hear that, but does the committee want to receive the information to just receive information about what a particular proposal does to the budget without knowing the overall picture? Doesn't seem particularly informative to my eyes anyway. I'm going to stop sharing so I can see if people are raising hands. Anybody else have any thoughts about this question? Was that a hand raise, Ellen? Or you're just waving at somebody? Okay, gotcha.
It's Dr. Calvin has his hand up.
Michael?
Also, I would share with you that I think it is important to know what the big picture is, because for whatever proposal we make or revision or amendment, we do it oftentimes, we shouldn't think of it as in isolation. So I would share the same sentiments with you as well too, Paul.
Leah?
I'm just a little concerned. Like, I don't think this is the venue to relitigate an issue that was extensively addressed through the Appendix I process. I know, Paul, you and some others disagree, but this committee and other state bar committees do not have oversight over the budget writ large. You are responsible for making recommendations about the fees assessed, and that's what was brought forward to you. And when there is the next iteration of that effort, similarly, you'll be very engaged in a review of the financials at that time. The board has adopted a policy that the fees be reassessed every 3 years, and in between wants to apply CPI adjustments. So it may be that because the board is more actively engaged in fees and sort of the revenue side of the equation, by default, the committee is going to be getting more frequent fiscal updates, because you'll be asked to look at the fees. And so I just think this isn't like a show of hands about whether or not you want to have oversight over the budget. In terms of getting information, the CFO provides quarterly financial statements to the board's finance committee and the board of trustees every quarter, as they're called. Those statements isolate out the admissions fund. I don't personally see any issue with providing you all with that information. That's something that's publicly available. It's the condition of the fund, revenues and expenses. And certainly all of the information that is provided to the board that specifies the condition of the admissions fund is certainly appropriate to share with the committee. And maybe what we can do is include, that as a posted material for the relevant agendas. I think, as information, that's fine, but I want to be clear that this issue of like oversight in the committee's role was extensively addressed, and I don't think we're going to unwind that here.
Oh, and I'm not saying that, I'm not asking for oversight. I've always understood our role to be, at best, what we can do is make comments to the Board of Trustees. And I'm perfectly happy and capable and have proven to be willing to do that. But we need the information. We could have of course, always just go out and grab it ourselves from what's available publicly on the board's agendas. But why should we have to work so hard to learn something that could be provided for us? So yeah, I'd be happy with you maybe just putting those reports on or links to them on the consent agenda when they come out.
I think that's a good idea. I think we could also do with those publicly available financial statements, sort of a data visualization about all the different numbers related to admissions that we could have either in the consent agenda or part of the director's report. So we could look at all the committee could see every meeting a snapshot of different, application numbers, the bar, things that we might say orally, but it might be nice to have a data visualization, and part of it could be that financial statement.
Okay. That brings me then, I was going to wait till later, but maybe now's the time to discuss it. The director's report, and I'm addressing this more to you, Leah, because I understand that your office has imposed this upon Audrey, is you've asked that the director's report on the agenda simply say director's report and not list the subtopics that she expects to be talking about. So that then means that we have no advance notice of topics that are likely to be discussed, and can gather our thoughts about those to be better prepared to ask questions when she makes the presentation. And then also, Audrey, I just hope that you're not simply going to provide that information on your screen as a shared screen, but it would be attached to the agenda so we can look at it at our leisure. Because I find when we're simply going through documents that are shared, that not all of us scroll through things at the same speed, and having to try to read it off the screen, formulate our thoughts, maybe go look something up that is triggered by seeing something, it just doesn't work. We need to see the documents in a way that we can appreciate them either before, after the meeting, or at a different speed than whoever is presenting it is scrolling at. So Leah, why is it so important that the director's report be so non-descriptive when it's on the agenda?
Well, I think you're mischaracterizing a message you may have received. There was an issue with a recent, I don't remember which meeting, because something was not delineated in the director's report, sort of table of contents or outline. We were advised by OGC that we could not talk about it, and we needed to talk about it. It's something that came up. We wanted to figure out a way to bring it to CBE. The executive director's report is a great kind of placeholder, as well as the chair's report. If you look at the board structure, this is how they're structured. Very rarely is there any specific articulation of topics to be addressed, because it allows for flexibility to bring issues forward to the board in that instance, or the committee here, so that it can be discussed. So I certainly think if there's action to be taken under the director's report, obviously that needs to be specifically noticed. But I also note that the director's reports, chair's report, does not need to be written. There's no requirement that Audrey or anybody else do a written report each meeting. It could be oral. And the contents of the report, it's okay for that to change. So that, I think, whatever message you got, I believe, was in relation to sort of this challenge we had. I can't remember if it was at the PBE or the BRC. It was one of these issues that we were trying to figure out, how can we bring this to the committee? And we couldn't, because of the way the director's report was structured. So there was no edict that forevermore you shouldn't, but I don't think it's a good idea. We don't do it on the board side because of the reasons I'm stating. You want to be able to be flexible about what you bring forward.
Well, yeah, I'm really wondering about that interpretation, that by saying nothing, you can talk about anything. That seems odd to me. I don't know if Gina's face is showing concern or what, but
no, Paul, I'm here. I think I think where this came up, Leah, if I recall correctly, it was regarding the PBE, and I think that what was contemplated was action in that case. But I'm not going to undo anything you've just said. I was just trying to look back, Paul, at where this came up, and it came up because staff wanted to allow action on the PBE recommendations, and because that wasn't agendized within the time frame required by the law, we weren't able to take that action at the August meeting, and that's why we had that separate September meeting. So that specifically had to do with action. Just
but that has nothing to do with changing a list of items that Audrey tends to address to a list that contains no entries. You would not have been able to deal with the PBE on that agenda if the only line item on the agenda was director's report. that's a whole different issue.
Correct.
Yeah. So I mean, I think there's a way to deal with, in the past, we had something like a miscellaneous or other items along with the list of, things she knew she was going to talk about. Anyway, I don't want to belabor this point too much I'm not sure everyone else is as concerned about it as I am. But
Paul, if I may suggest, before every meeting, Audrey goes over the agenda with the chair and the vice chair of the committee, and that can be part of that discussion in terms of, right, are things appropriately put on the consent calendar? What should be on the director's report? That is, I think, fine for that discussion. It doesn't seem to be the most productive use of our time right now, though.
no, I agree. But I don't know that they're as sensitive to the Bagley-Keene concerns as I am with, my years of experience having to deal with it.
Well, I
anyway,
think the most
okay.
important thing is that we're sensitive to the Bagley-Keene concerns, and so we will make sure that we keep on top of that so there isn't a violation of Bagley-Keene.
Right, but I will simply say one last comment. It's a disservice to the public for them not to know what, of topics Audrey knows she's going to be talking about in advance to decide if they want to stick around for that portion of the meeting, which always now comes at the end. So, okay, moving on. Any other items to add to now exams, formerly operations and management? Okay, then we have Ed Standards, which is subcommittee I'm chairing this year.
Paul, can you share your screen again?
Yep, sorry. So we have on the plate reviewing the unaccredited law school rules. As I mentioned earlier, they haven't been updated in quite a while. This is on a bit of a pause because we're trying to wait and see what comes of both the question of should we be pushing unaccredited schools towards mandatory accreditation, and also the eligibility rules, how they end up deciding a few things about foreign legal education and those kinds of things. But we will be getting to them in the near future. Here's mandatory accreditation. We discussed bringing that forward fairly soon. We've completed, I believe, the work on improving the accredited law school rules, having enacted them a couple years ago, and now we're simply working on the joint accreditation. And unaccredited rules are described up above, so I'm not sure we need this item anymore. And these two trainings are on the training list. Okay, we have the CS Bars meeting and the Law School Council, along with a newsletter for the deans. Reviewing petitions that we get from law schools over time. Reviewing the progress reports and annual compliance reports. The 5-year minimum cumulative 5-year pass rate. We review annually as law schools report them. And that's the end of that list. Let's see, we need to add Alex's item about helping the law schools improve their curriculums. And let's see. I think that's it. Vince, go ahead.
Would it be useful to have a list of the schools that are going to be reviewed for the year? Because I know that comes up in some sometimes we recruit people from outside of this particular committee to participate. And that way we can just better anticipate a schedule.
Yes, actually, Vince, we are in the process of creating those and plan to have a proposed list in the month of January. We'd be happy to share that.
Fantastic.
Okay. So let's see, I think, anything else anyone wants to add to the work plan?
Paul, would you want to add the referral from COPRAC, urging the
yes,
committee to
yes.
consider whether or not to have an AI-related policy for schools?
Yeah, and then I think there was one more that was on the slideshow.
It relates to, I think it could actually be folded into Alex's proposal related to the Kappa BRC learnings.
Right, okay. So Amy, if you can take a stab at incorporating all that for our review next time.
Of course.
Do we need something for 2-day meetings? I guess it would be under examination, since that's kind of the successor to operations and management.
Yes.
Okay. And I think that's all I wrote down. So my assignment is to bring back the consensus, or the consensus memo in a revised form for review next time. And with that, I thank you all for your indulgences.
Dr. Cow,
Yes.
getting back to the prioritization of the work plan items that we were talking about, it's helpful to go through the work plan, and we obviously talked about a lot of this during the planning, but just wanted to make sure that it was your opinion that we should do the prioritization after the staff incorporates all the edits in January.
Yes.
Okay.
Yes, that sounds great, Audrey. Thank you for bringing that up.
Oh, and Amy, I gather there is a parking list somewhere, parking lot?
Yes, there is.
Okay, so be sure and provide that next time too, so because we may want to move up some of those items, but also move down some of the ones in the main work plan.
Okay. We'll bring that.
Paul, were you going to say anything else?
Just that's it. Thanks.
Thank you very much, Paul, for presenting the points of consensus as well as the work plan. I just want to remind everyone on the CBE that we can always revisit the work plan later. So as things develop or things arise. So I just want to bring that up. Paul, would you mind bringing down the shared screen? If that's okay. Yeah, thank you. So we're going to move on to the next item, which is our consent agenda. So I just want to remind everyone that the consent calendar is voted on and is approved as an omnibus item, meaning that one vote for the entire calendar unless a board member decides to vote something off the consent calendar. So first of all, this is the report on administrative updates regarding law schools. Are there any questions or comments on this? Okay, so if there are none, may we get a motion for the consent agenda?
So moved.
Thank you so much, Alex. May we get a second?
This is Judge Masuala. I'll second.
Thank you so much, Justice. So are there any discussions or anyone needs to pull anything off the calendar for this? Looks like none. So if that's the case, Devin, may we get a roll call vote?
Dr. Bolton? Dr. Bolton? Robert Brody? Alex Chan?
Yes.
Jim Epting?
Unmute here. Yes.
Kareem Gangora?
Yes.
Paul Kramer?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Justice Macy Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 12 yeses and 0 nos, the motion passes.
Okay, thank you, Devin. Moving on to agenda item number 3, which is actions on the implementation plan to change format of the first year law students examination to a multiple choice exam. So I will turn that over to Lisa and Amy.
Yes, thank you, Dr. Cow. I have a PowerPoint presentation that Tammy will be running the slides for. So Tammy, if you can pull that up, that would be very helpful. Thank you. Okay. So at the October meeting, the CBE voted to eliminate the essays for the first year law student exam, and also requested to review the implementation plan, which we will be discussing here today. As you can see in slide 2, we can move there. The current version of the exam includes 4 essays. They are 1-hour essays and a 3-hour session of 100 multiple choice questions. The new version will remove the essays and include 100 multiple choice questions. Next session. And one thing, Tammy, you're in presenter view, and I'm wondering if you could switch that out. Yeah, in the settings. Okay. All right. So there are a variety of tasks, obviously, that are required in order for us to make this transition. And so as noted in the agenda item that accompanied this, staff have started some of these tasks, and they were started as part of that first year law student exam refresher project, which is allowing us to implement this change for the June 2024 first year law student examination administration. For example, one of the tasks that has already been accomplished is the preliminary review of the content map and the item bank. That was conducted with help from the deans, faculty, and administrators from California law schools. In the next slide, if we could go there. One of the things we're going to do later today is we're going to bring the end product of that work that was conducted with the law schools and with our psychometricians, the content map for the committee's approval. I'm going to walk through some of the items here to describe what the remaining tasks that are required for us to bring us to a June 2024 implementation. So once the committee approves the content map, the psychometrician and the EDGE team will reevaluate the item bank to ensure that we have sufficient and high rating multiple choice items covering the approved content area. And that blueprint review will be taking place. And that goes hand in hand with the next item here that's scheduled, the gap analysis between December 2023 and January 2024. In that gap analysis, the items would be coded by our psychometricians to make sure that we meet the map, that the whole map is covered, and that we build the banks, that the forms are built covering the bank. In terms of the review of the archival data, What happens here is the items are evaluated using statistics to determine what is retained, what is revised, and what can be removed from the item bank. And that is done in conjunction between the psychometricians and our staff. In March, the forms are drafted and developed for review. And in March, there is a standard setting that would be required. So as many of you know, currently the score is comprised of a combination of the essays and the multiple choice. Each of those two components represent 50% of an applicant's score. So given that 50% of that will go away, the psychometricians will have to conduct analysis to determine what the new cut score should be, since the score will be comprised solely of the multiple choice sections. So this is a standard setting. And what we're suggesting here is that the psychometricians come and present to the CBE, perhaps in March, to discuss both the process and the findings on the standard setting. So the CBE will be fully informed about both what that new standard setting will be and how the psychometricians came to that conclusion. So once that happens in March, the next step is to administer the forms in June. So again, the idea is that in June, we'd implement the new exam format. And if the committee approves, then in July, we would implement the new scoring. The new scoring would happen with the first administration of June. Next screen, please. And so if the committee finds this implementation plan reasonable, then this is the motion that's on the table, which is to move that the committee adopt the implementation plan to change a format to all multiple choice exams starting with the June 2024 first year law student examination administration. So with that, I'm going to open it up to see if anybody has any questions or thoughts or suggestions.
Couple of questions.
Okay.
So if something goes wrong, if your best guess at the feasibility of getting this ready for June doesn't pan out, do we have a backup plan?
I think we would just continue to administer the exam the way it is. So,
So you'll have essays ready?
Oh yeah, we do.
Okay. Let's see. I would simply ask that future updates be described on the agenda in such a way that we can not only discuss your report and ask questions, but take action if necessary to either to give you additional authority or to direct you in some way. In other words, not just a report, but a discussion and potential action type listing.
Like we did this round.
Yeah.
Okay. All right.
So we don't end up with a Bagley-Keene problem that, we really need to do something and you want or you want us to do something, but we haven't set up the opportunity to be able to do that.
But this one is agendized as an action, or what word were you looking for in the agendized title?
I'm not sure, just not just a report, or an informational report or something like that on the status, but just making it, leaving it open the possibility that we may have to, either because we want to tell you something or because you want us to give you the authority to do something, we can do it.
All right. Any other thoughts or questions? Thank you, Paul. All right. So I'll leave this motion.
Yeah, so I was gonna ask Amy, so do we have to call for a motion before we discuss it then? Or do we, are we allowed to discuss it now and then
Okay, yes,
do a cover?
the discussion.
Okay, so that's yes to we call for a motion and then we can discuss it?
You know,
I'm
actually,
just
Rosen,
asking from a
Under
procedure
Rose,
standpoint.
oh,
Go
sorry,
ahead, Caroline.
Michael. Under Rosenberg's rules, you're supposed to have a motion before discussion, but you know, it's not always it's not if you discuss it before the motion, there's no Rosenberg's rules police that are going to tell you that you have to go back and undo what you've done. But technically, yeah, you're supposed to put a motion on the
Okay.
table and then discuss after.
Okay, thank you for that clarification, Caroline, especially there's no Rosenberg's police that are going to.
Yeah, it's supposed to help focus the committee's discussion so that it's not like all over the place, but that that every committee member sort of knows what's being discussed and has like some guardrails around it. I think that's the intent behind it.
I think it also gives the appearance that maybe the committee's made up its mind ahead of time, which is unfortunate. And I think it's silly, but I will make the motion.
May we get a second for the motion?
I'll second. This is Justice Mesiwala.
Thank you so much, Justice. Now, are there any other questions, comments, or discussion about this motion? We actually have not made up our minds. I want to clarify that. I just want to make sure we follow Rosenberg's rules and we are now allowed to talk about it now. So are there any other comments or questions about this? Okay, hearing none, I guess, Devin, will you go ahead and do a roll call vote on this?
Dr. Bolton? Robert Brody? Alex Chan?
Yes.
Jim Epting?
Yes.
Kareem Gangora?
Yes.
Paul Kramer?
Yes.
Larry Kaplan?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Justice Mesiwala?
Yes.
Bethany Peak? Ashley Silva Guzman?
Yes.
Judge Reyna? Vince Reyes?
Yes.
Alan Yokelson?
Yes.
Dr. Cow?
Yes.
With 11 yeses and 0 nos, the motion passes.
All right. So it looks like it's 12:05. So I wanted to ask everyone's opinion if we would take a 30-minute lunch now, go back to open session, and then Audrey, can you remind me, we have a 1 p.m. set special session that in closed session, is that correct?
That's correct.
Okay. So does that sound okay with everyone if we take a 30-minute lunch? I see some yes nods. Okay. So it looks like it's 12:05. So at 12:35, we'll all come back to open session. Enjoy your lunch.
Good afternoon, Adrian.
Yes. Okay.
Recording ads or stop video. Audrey, does it look like we have most of our members back yet?
Can everyone try to turn their cameras on if they're ready so I can make sure that we've got everyone back? I'm seeing some more faces.
I love it, Dr. Cal. You run a tight ship.
I hope that everyone will still like me after each meeting.
I'll give you 2 thumbs up on the timing.
Thank you, sir. Appreciate it.
Devin, are we seeing quorum back? I think so.
We do.
I think we can start, Dr. Cow.
Okay, thank you so much, Audrey. So we will continue. Just keep in mind that we have a 1 p.m. set session in closed session that's listed. So we'll have to switch off to that regardless of wherever we are in this open session discussion. So we're going to go to agenda item number 4, which is action on revisions to the admissions rules pertaining to Chapter 6 conduct violations, recommendation to circulate for public comment.
Dr. Cow?
Yes, ma'am.
Sorry. You know what? Just because I imagine Tammy's Chapter 6 item might have more discussion. Did you want to do the Ed standards item out of
Sure.
order? Maybe that would
Absolutely.
be in terms of timing.
Great, I love
Sorry.
it. Thank you. Thank you so much for that recommendation. So we will pivot and we'll go to agenda item number 5, which is action on major change addition of pre-admission program, Purdue Global Law School. I'll turn it over to Natalie and Jim.
Hi, Alex and Dr. Cow. I think that Paul has actually prepared this one in his new role Back to the Future as chair of Ed Standards. I wanted to let folks know that the Dean of Purdue Global Law School, Dean Martin Pritikin, is here. You'll recall that the school historically has been called Concord Law School at Purdue Global University. And as they advised you in August, they changed their name effective November